everyone. This is Allison from Upwardly Global. Thank you for joining us for today's webinar presented by Upwardly Global and Fragomen. Just a few housekeeping notes. Today's webinar is listen only. All lines are muted. However, please feel free to chat questions throughout the webinar. They will be addressed during the Q&A session. If we don't get to your question, please feel free to follow up with us after the webinar. You will find contact info at the end of the slide deck. If you're having technical issues, please chat us for support. This webinar will be recorded. We will send you an email once it's online. If you would like a copy of the slide deck, please let us know. Feel free to participate in the polls throughout the webinar, as well as the survey at the end. I'll now turn the mic over to begin the webinar. Thank you again for joining us today.
Good morning, everyone. My name's Anne Kerwin, and I lead Upwardly Global in the Bay Area. We're a national organization that acts as a bridge between corporations and a talent pool that's often under-recognized and underutilized. This pool is mid-career professionals who have been educated outside the U.S. and have come here as legal permanent residents. When they arrive here, it's a new country, and a U.S. job search is challenging. So we help them understand the structure of the workforce, target positions that appropriately leverage their skills and experience, and successfully navigate their way to a professional job offer. These international professionals represent the face of the future. The U.S. workforce is changing, and 85% of its growth over the next 20 years will come from immigrants and the children of immigrants. In fact, by the year 2050, 1 in 3 Americans will be Latino. These workers bring language skills, management experience, and international business savvy. Many also have in-demand STEM skills. And they have soft skills that employers value, like resourcefulness and tenacity. As I said at the outset, as well as working with candidates, we also work with employers. We help companies like yours tap this pool of mid-career professionals through resources like a job board, dedicated account management, and careful candidate screening. We can also provide corporate volunteering opportunities for your employees that build their cross-cultural communication and leadership skills through mock interview and other events. Upwardly Global has a national footprint with candidates from almost every state in the U.S., 40% of whom are willing to relocate for the right opportunity. And so far, we've helped close to 3,000 immigrant professionals find their first jobs in America. Today, we're really excited to partner with Fragomen Worldwide to talk about a new talent pool of internationally trained professionals. That's the spouses of H-1B workers. This group previously hasn't been allowed to work in the U.S., but as of May 26th, Tuesday of this week, they have a pathway to employment. So now I would like to introduce our speaker, Cynthia Lange. Cynthia is a managing partner for Fragomen Worldwide, a leading corporate immigration law firm. She heads up the firm's Northern California practice in representing a wide range of companies, from Fortune 500s to emerging startups. She also manages the Fragomen I-9 Service Center. So we are in really expert hands today. And now I'd like to hand off to Cynthia.
Great, thank you so much, Anne. I look forward to talking with you. Let's go through the agenda just briefly. It's going to be a short call, and we want to make sure we save enough time for you to be able to ask questions that you have. But we're going to go over just overview of the new employment regulation, talk about which H-4s are eligible for work authorization, talk a little bit about what the filing process and processing will look like at the government, talk about a couple of unusual situations, some qualifications and exceptions, and then go through what type of employment is permissible and sort of the ease of doing this. So, and then we'll go to the question and answer session. Let's begin. The new H-4 Employment Authorization Regulation, as Ann said, just came into effect. We've been anticipating it for a while, and over the last few months we've received so many phone calls, both from principal H-1B workers and also from their spouses. As you sitting at companies know, this has been greatly anticipated and really welcome with a lot of fanfare. In fact, it's probably one of the things that has helped boost the morale of your H-1B employees, that their spouses are able to work. The purpose of this reg was to facilitate people coming into the United States and being able to have their families work. The recognition was that the green card process took so long that somewhere along the green card process, spouses of H-1B workers should be able to get the benefit of being able to work. The USCIS issued guidance very recently, just late last week, giving a little bit more information on this and began to accept work authorization applications. So, the new regulation makes eligible certain H-4 spouses of foreign nationals. Not every single foreign national spouse can work. Who can work? Well, people who have a spouse who's either got an I-140 that's approved, and that's the second stage of a three-step green card process. It's after the perm, but it's before the processing for the final green card. The I-140 doesn't have to belong to the current employer, doesn't have to be your I-140. It can be an I-140 from a previous employer. The principal's green card category doesn't have to be backlogged. It can be current. So while this is a huge boon for people from India and China that have backlogged priority dates, somebody from the UK or Singapore or France can take advantage of it as well. And you don't have to be so far along that the person's been here 6 years. An approved I-140 can be obtained in a matter of a year or two after someone starts working for you in some cases. So it could be actually pretty quick. On the other hand, if somebody has been here for 6 years or more and they've extended their status beyond the 6-year extension, they are eligible for having their spouse work as well. In that case, they have to have the approved 6-year extension, and it can't be pending. It actually has to be approved before the EAD is applied. So these are people that have been here a little bit longer, but not outrageously long periods of time. And nimbler companies that we talk to have already taken great advantage of this. Some of you on the phone may be in that category, where you're using this untapped resource of spouses of H-1B workers to be able to, one, boost morale of your current employees, and two, be able to maybe tap in, as Ann said, into another group of workers. It's an opportunity to access this talent and provide an employee benefit at the same time. So what are some miscellaneous issues that we're coming across? Well, an H-4 who also is an applicant for adjustment of status, although they can get an EAD through the adjustment of status, may choose to use the H-4 EAD. Why? Well, the H-4 EAD can be issued for the length of the H-1 period of time or the H-4 period of time, which could be up to 3 years. That could be a longer EAD than the adjustment of EAD. Now, the adjustment EAD does come automatically, so there's in some cases when the adjustment's first filed, the fee isn't as great with that. However, the benefit of getting it for a longer period of time may bode or turn people towards using the H-4 EAD rather than the adjustment EAD. Also, spouses who are in another non-immigrant status, let's say they're an F-1 student or a J-1 student, they may switch to H-4 status to be able to get this benefit, even though they may not currently be in that. They have to first get H-4 status, and then they can apply for the EAD. And just one minor point, children of H-4, H-1B workers are not eligible. This is only spouses that are eligible. So people may ask you about how difficult is it to complete the 765. Now, this is a little bit different exercise than other EAD applications, which simply you have to check a box to show you're eligible. In this case, there's a little bit more evaluation that's involved in it, but it's a much easier process than doing an H-1B petition. In fact, it's really quite valuable in that it doesn't require, and we'll talk about this in a little bit more depth, but it doesn't require an LCA ahead of time from the Department of Labor. It doesn't require any labor market testing like some other visa categories do. You simply are able to go right to the 765, and employers are jumping on providing this service for the spouses because the cost of doing this is relatively inexpensive compared with the cost of doing an H-1. For example, it could be, at least a half to a third less expensive than an H-1, and in some cases, potentially even more. So the Form 765 has to be completed. The Immigration Service just released a new one, but for the ones that are being filed right now, if they've already been prepared on the old form, you can continue to file it using the old form. The eligibility criteria we've gone through. The new form does solicit receipt numbers from the H-1B principals underlying I-129. So there's a lot more information that will be required for this than just another EAD, but it's information that would maybe be available. One thing as an organization you may need to think about too is you may not have given some of the information that's going to be requested to extend the work authorization to the spouse may not be information you regularly give your H-1B workers now. So there's some organizations that had to set up a process to think through what information do they need to give their H-1B workers so their spouses can apply for work authorization. And some organizations are simply doing it directly. They're doing the applications for their spouses so they don't even have to give their H-1B workers the information. They can simply process it directly for the spouse. Now, most EADs take about 90 days or less. The Immigration Service works hard to keep under that time frame. However, we are hearing from the Immigration Service that it's likely that because they're expecting such a huge influx of applications the first month or so of this, and that they don't know exactly how many, but they are expecting a big influx right away, that they are warning people that EADs may take longer than the typical 90-day period that's expressed in the regulation. So be prepared that not only these EADs, but maybe other EADs may be subject to more delay. And to underscore that, recently the Immigration Service suspended premium processing for H-1B extensions because they're expecting they need those resources allocated to adjudicate these spousal EADs for H-4 individuals. Just a little note, if the I-140 isn't yet approved, you cannot file concurrently for the EAD, but you can file concurrently if the H-1B is extending their H and they don't yet have the length of time. You can file the H-4 EAD concurrently, but the extension has to be approved first, and then the Immigration Service will adjudicate the EAD. So let's move on to documenting the eligibility. What documents do individuals need to have? Now, interestingly, I pointed this out earlier. You'll notice there's no labor market testing. There's no minimum wage requirement. You don't have to research what the wage requirement is in the marketplace. The requirements are really relatively painless for employers, but it will require that the employers do provide some level of documentation. If the person is eligible because there's been a post 6-year eligibility, the principal must provide the actual extension, proof of the extension. If it's based on an approved I-140, they have to actually provide the I-140. In addition to that, there has to be the principals or the spouse who has the H-1B. We need to have their valid H-1B status. That probably would involve having the petition number and the I-94 card. And we also have to establish the relationship between the spouses. Most likely that would be a marriage certificate that would be sent with that. So while it's really a painless process, it does require a little bit more than just checking the boxes and sending it in. What if you don't have a copy of the approved I-140? Let's say it was a previous employer's. Or even the I-129, we've posited that there may be other evidence that could be accepted. For example, information about the underlying petition, like the receipt number or names of the petitioner and beneficiary, may be something that they'll accept. For approved I-140s, a printout from the screenshot online of the USCIS's case system. For post-6-year extensions, also maybe a printout from the online case status system, or approval notices, passport admission stamps, I-94 card printouts may also be able to evidence that. As a long shot, potentially affidavits could substitute for that, although we do think that's a bit of a long shot, maybe in some circumstances. For example, if something was lost or stolen and there's a police report and an affidavit that accompanies that, maybe that would do in a pinch. And then, of course, there's always a FOIA request, a Freedom of Information Act request, which may help to document eligibility. Our recommendation is, of course, that if you're in one of those categories, that you consult with expert legal opinions on that, because that really gets into a gray area about how to convince the Immigration Service that somebody's eligible. Let's move on to government processing. So government processing, we expect, as we've said, the government is geared up in many ways. We know that they're ready for this. They've done some estimates that they think maybe 180,000 spouses may apply for this category. Just like with the HCAP, it's always hard to tell, and these are only guesstimates. We've found with the HCAP, though, that always the estimates have been exceeded by reality, so that's possible here as well. Getting the EAD applications in early is important. One thing to note about an EAD, and that really relates to the government processing times. Unlike an H, where you simply file the extension and you automatically get 240 days of continued work authorization, an EAD has to be approved to continue to work. So they may get their first EAD for 3 years, and then they go to maybe get the extension, and they cannot work past the expiration date on the extension. They have to have that in hand approved and document it and show you the original for I-9 purposes to be able to work. So government processing times for EADs will become very critical, and planning ahead of time for extending EADs will become very important. So important to know that while we'll experience probably delays initially, the government will bounce back to the regular 90-day processing time. So you want to make sure that you never file an EAD extension with less than 90 days. You want to make sure you give a minimum of 90 days to the government to be able to because what happens is, in normal circumstances, if the government hasn't adjudicated the EAD within 90 days, they will entertain requests to expedite the processing or speed it up if we're getting to and remember that if the extension isn't yet approved, the government won't expedite or won't even adjudicate the EAD. So that's clear today, but keep in mind, if you get an EAD for 3 years and you're getting ready to extend the H-1B workers' H-1B, you may want to make sure you start really early so that you've got the approval more than 90 days before the spouse's EAD expires. So you're going to get a lot of H-1B workers who are on top of extensions for their H-1Bs now. Maybe they were unresponsive in the past. They're going to be all over it. You're going to have very responsive H-1B workers now in responding to trying to get their H extension filed early. And remember, you can file an H extension at least 6 months before the date you're requesting. So all the timing should be able to work out well and not have to lose any time on the H-1 by applying extra early. So what's the impact of a couple of things on the EAD extension? So a bit of detail about the eligibility and timing here. USCIS has clarified that if an H-4 EAD applicant is traveling abroad, they can do so in valid H-4 status, so the travel alone shouldn't delay the EAD application or cause it to be deemed abandoned. However, they may get a fingerprint scheduling notice during the time that they're traveling. If they get it while they're traveling and they can't make the appointment and they have to reschedule, that will delay the issuance of the EAD. So keep that in mind. You may advise your employees' spouses not to travel until they get the fingerprint notice so that they don't delay their application in any way. But if a spouse is not currently in H-1B status, we talked about earlier, maybe they're in F-1 status or they're in J status or some other status, and they're switching to H-4, they may not travel and until the status is approved, because traveling while it's pending may cause the change of status to be deemed abandoned. That's not the H-4 EAD, that's just the status, and then you have to start all over again. So you want to make sure they get the H-4 status before they travel. You'd hate to have to see them refile. Moving on, what's the impact of an I-140 or I-129 revocation? We talked earlier that the I-140 doesn't necessarily have to be from you as an employer. It can be from a prior employer. But prior employers are sometimes notorious for revoking an approved I-140, for example. And if the I-140 is revoked, the H-4 spouse will be ineligible to apply for an EAD. So a revocation of I-140 is really devastating. You want to make sure that that I-140 remains valid. Keep in mind that the USCIS has the discretion to revoke an approved H-4 EAD after an underlying I-140 is revoked. So even if it's valid at the time the EAD application is filed and is revoked later, it's possible that the USCIS legally can go back and revoke the EAD. Now, it's hard to decide and determine to look into our crystal ball now to know whether they'll do that. My guess is it's less likely. That's a lot of matching, a lot of things together, and a lot of work for the USCIS. So my guess is it's probably less likely they'll do it, but it remains legally possible, and you have to be aware of that possibility. The USCIS has not commented on the ability to revoke an EAD if there's a revoked I-140, but I think we have to think that potentially that could happen. So let's go to sort of our last slide, and so keep those questions coming. We want to be able to get to your Q&A very shortly here. What type of employment is permissible under the H-4 EAD? And the great answer is pretty much everything. It's not limited. It's not limited to a particular industry. It's not limited by their degree having to be related to the employment that they're taking, and it's not limited by a prevailing wage requirement that you have to go to the Department of Labor and get approvals. In fact, it's a very rich hiring opportunity for employers with a very broad-based employment authorization available, and it's much more flexible. If somebody moves locations, if they change jobs, if they get a promotion, nothing is put in jeopardy. The EAD will apply to all those categories. The pool would be available to work relatively quickly. There's no quota. They don't have to wait for an H-1B quota number to be available and the H-1B to be adjudicated. And the cost is far less than it would be to do an H-1B. The EAD should be valid through the expiration of stay on the H-4's status. And it can also be used to obtain a Social Security number, which, of course, if they're employed, they'd want to. But it opens up a lot of opportunities for the spouse as well, as having a Social Security number. And the EAD is not only authorization to work, but it's also acceptable proof of identity. And it will help facilitate a lot of things like driver's licenses and other types of applications, bank loans, opening up bank accounts. There's a lot of avenues that will be opened by a spouse having an EAD, which is an identity document issued by the Immigration Service. So with that, I think I'm going to turn the time back over to Upwardly Global, and we can see what questions you have out there.
So thank you so much, Cynthia. That was an incredibly clear and comprehensive presentation. And this sounds like such an attractive talent pool for employers. As you mentioned, there's potentially 180,000, and the processing costs are going to be a third to half of the cost of hiring a H-1B worker. And it looks like the processing time should be in and around 90 days. We actually have a question with regard to the processing time. And the question is, the presenter mentioned EADs are generally 90 days or less, but hasn't the agency actually been lagging significantly? Thus, the recent lawsuit filed on the point of delays on EAD applications.
It ebbs and flows. The EAD processing time ebbs and flows. There are times when we get them under 90 days, actually quite a significant amount of time. But yes, the agency has had trouble sticking with their 90-day benchmark that they give in the regulations. The value of using the 90-day benchmark is that I think and let me address the lawsuit as well, but the value of the 90-day benchmark is that you are able to go to them, and they do use that as a benchmark to try to hit. And if you haven't hit the adjudication in 90 days, we do find that congressional representatives, senators, their offices will be helpful after the 90-day period, and you can make inquiries after the 90-day period. So the 90-day period is important because it's a trigger for being able to go to the next step, which doesn't exist before that. But absolutely, unfortunately, there have been times, particularly in influxes of other types of applications, where they have lagged significantly behind. I think that the lawsuit is meant to address what the government does after the 90 days as well. Okay. What the regulations say is after 90 days, the USCIS, or it actually originally said the INS, will issue an interim work authorization. Mm-hmm. And they used to do that. You used to be able to go down to the district office and they would issue work authorizations. Now they took that ability away from the district offices, and when they did that, they didn't really put a mechanism to ask for work authorization after the 90-day period in some other way. And I think that's really where the bone of contention is, mm-hmm. is that they're not creating a mechanism for, if it's taking longer than 90 days, the regs provide for an interim work authorization to be issued, and there isn't that. It's a little nuanced, but that is really what I think everybody's really upset about, is that, okay, if you're going to take longer than 90 days, at least honor your regulations, and they're not. I think that's the problem.
Yes. Okay, thank you very much for that. And I just want to remind people that if you want to ask a question, if you use the chat box, which is on the lower left of the screen, and flag that it's a question by right-clicking on the chat message. There are some other questions that have come in to us. Another one is, how are the spouses of H-1Bs being notified that they are now entitled to apply for work authorization?
Oh, fabulous question. And in fact, we have the right constituency on the phone, because unless they're looking at, the website, the government is not taking any action to notify them.
Mm-hmm.
It would really be exclusively on the individual's own initiative to look at that up, or what most employers we work with are doing is they're notifying H-1B workers that their spouses have disability. And so a lot of times H-1B workers do look to their employers to help keep them informed about benefits and avenues that might benefit their family or them. An H-1B worker can sometimes within 90 days or maybe 120 if the EAD takes longer, double a family income. I mean, they can double their family income. This is a really important piece of information. If you haven't notified your H-1B employees already, that would be a great thing to do. Even if you're not covering the cost of doing it, just giving them that piece of information, I think, could really benefit them. Now, keep in mind, what you as an employer have to balance is if you're not doing green card applications for your H-1B employees, the pressure may be on to do green card applications. So that piece of information will have a corollary result, which is starting green card applications sooner. Most of our clients start really early, but if you're not in that category, just be aware that that's probably going to become a pressure not only for your existing H-1Bs, but I think you probably want to talk to your staffing organization and your recruiters, because you're going to start finding that people that take H-1B jobs at your company, one of their questions along with when are you going to start a green card is, will you help my spouse get work authorization? And that entails at least getting to the I-140 stage.
Okay, great. And in your experience, Cynthia, you mentioned that some companies are being very nimble in this regard and have already moved forward with, support for the legal process. What percentage of H-1B employers do you think are going to directly support this path to employment authorization for the spouses?
Wow. So that's a really good question that nobody knows the answer to right now. We've seen some benchmarking. Many employers are still, a little bit reticent to go out there with the benchmarking, but we've seen some benchmarking, and it varies by industry. I think, we're here in the high-tech capital of the world. I think we're seeing more companies do it than not. But it's still something many companies are looking at and studying. But I think that companies are watching, waiting, looking at what others are doing as well. And some companies have jumped in whole hog, had sessions with their employees and are providing that benefit to the H-1B workers.
Okay, great. So I have a question here. How would an employer hire the spouse of someone not working at their company? Is this possible?
Sure. If you're aware, there's a couple of different ways. I mean, obviously, if they get their EAD and then they go out and they go in the marketplace, you'll find that they'll be part of the applicant pool. If you're aware of somebody that's a spouse of an H-1B that hasn't yet gotten their EAD, the steps you have to go through is to help analyze whether they're eligible yet. Does their spouse have an approved I-140? Is their spouse past the 6 years of their H-1? And if not, when could that happen and how could that happen? Those are some of the evaluation points that would happen. Now, one of the other things as you talk to staffing, I mentioned earlier, one of the strategies those employers on the phone may want to do is to do a briefing for their staffing group. Part of the briefing for their staffing group would include what is permissible to ask a candidate and what's not. You want to be careful. I know a lot of times they're asking questions because they want help and they want to dig, but some questions elicit maybe impermissible information about someone's immigration status that could be deemed discriminatory if you don't offer the job. And so you want to be careful and make sure that you get enough training to your staffing people that while they're aware of this, they don't, they know what questions should and shouldn't be asked.
Okay, great. This is a slightly different question. What are some of the challenges you envisage this group facing in securing employment in the U.S.?
It's a good question. I think there could be some employers, maybe less savvy than the ones on the phone, who may not understand what an EAD is. There are some employers who still impermissibly are saying you can only work here if you have unlimited work authorization or permanent work authorization. Those phrases are actually illegal in most cases, but some employers may not understand the parameters of that. So it may be that educating, an H-1B or an H-4 spouse who has an EAD may need to come armed with how to educate a prospective employer about their work authorization.
And this is a general question about the demographics of the H-1B spouses. Do you have a way of estimating the number of these spouses that will have professional backgrounds?
Yeah, it's a good question, and it's something actually, Anne, you and I have talked about.
Yep.
We know anecdotally, we speak with a lot of H-1B workers every day, thousands and thousands, and we take surveys of them as well. And one of the pieces of feedback we get both through surveys and anecdotally is one of the biggest priorities for them is being able to get to a stage where their spouse can work. You can imagine professional spouses go crazy, sitting around not being able to work. They look for volunteer opportunities. But here they have the ability to actually earn good money. So certainly I think that is a very important issue for H-1B workers. We just know that both from interacting with them and also from taking surveys from time to time with them.
And I would say, from the perspective of our work, we work with people who are permanently work authorized, but many of them have spouses that, don't have employment authorization. And some of the gaps that I would see them facing is gaps in employment, which are always difficult when an employer is screening a resume quickly, as well as licensing issues also faced by immigrant professionals, and issues in understanding the U.S. workplace and how to navigate it. And I suppose just to put in a quick plug for Upwardly Global, this is something that we could help employers with because, as I mentioned at the outset, we've already worked with about 3,000 immigrant professionals with very similar backgrounds. So moving on to the next question, what happens if a H-1B changes employers? How does that impact the H-4 EAD?
It's a fabulous question. As long as the H-1B worker maintains the H-1 status, their H-4 spouse will be deemed invalid H-4 status. And actually, the spouse doesn't necessarily need to do anything. The H-1B worker can simply change employers, and the H-4 spousal EAD will be deemed to continue. Hey, good news, huh?
Very good. Cynthia, do you foresee the agency extending the suspension of premium processing beyond 727 due to either the ongoing influx of H-4 EAD and or the influx of H amendments triggered by the AAO decision in April? I hope I asked that question correctly. It was very technical.
You did, and it's a fabulous question, and it's one I've been wondering about and we've been wondering about ourselves. And let me explain the conversation USCIS is having with itself right now. On one hand, they're saying, we really can't let our processing times get behind, and we have to be able to stick to the processing time. And we need to be able to provide that kind of service for our constituents. And they do talk that way. They do feel like they're constituents and it's a service they provide to people. And so there might be a temptation to extend the ban on premium processing. On the other side are the finance guys. They get $1,000 per case, or $1,200 for premium processing, and that makes a huge difference. They're very motivated by that extra money to be able to get the extra money into the USCIS. So there are competing interests. And they're having this conversation with themselves, which is a good thing, because those of us sitting out here sort of feeling at the mercy of the processing of USCIS will know that they have a motivation to get their act together and to be able to get the processing times down enough that they can reinstitute premium processing. There will be a significant loss to the coffers of USCIS by turning off premium processing. This is not just a boon to the USCIS that they get extra time. They're going to be working hard to be able to get back to processing times. And my guess is they just didn't have any idea, and this was a precautionary action, and that they're going to be working very hard to try to get that.
I think this question you've addressed in part already, but you may have some additional comments on this. The question is, how is this new regulation being rolled out?
Actually, first of all, it took a long time getting here, almost a year from when they first put out the initial proposed reg. Then President Obama in November made the big announcement. Then we waited and waited for the final reg. Then it was a few months, giving the H-1B cap cases time to be filed before this rolled out in May. So it felt almost agonizing to some people, but it's being rolled out in a way that's very cautious. And let me also address another question, Ann, you asked earlier, and that was, will the lawsuit that existing in Texas against some of the other presidential initiatives affect this? And the answer is, it's very unlikely to, because they've been very careful about following the Administrative Procedures Act, the APA, and issuing this regulation. That, that's not to say no one will ever file a lawsuit against this, but they have rolled this out cautiously. And I think that, that this reg has been rolled out in a way that they hope that, everyone expects this will withstand scrutiny.
Okay. How do we know if the H-4 EAD is valid and not out of status? Does the employer have any legal liability to check the status?
That's a fabulous, fabulous question that I've wrestled with for the almost 30 years that we've had I-9 rules around, 29 years, 30 years next year. And I think that that's really an I-9 question. And my recommendation always is in the I-9 arena, be careful not to go too deep. Now, if you know someone is not authorized to work, you can't employ them. But on the face of the EAD, if it's valid, you can accept it, and unless you have any information that the EAD has been revoked, it will still be valid for I-9 purposes. It is always and still been a little bit of a gray area question. If the EAD is valid, even if the underlying eligibility at some point goes away, it's a bit of a gray area whether that person continues to be authorized to work. My recommendation is that employers go to their immigration counsel and talk through how to put a process in place. Typically, from an I-9 standpoint, you wouldn't be digging into someone's background. You take an I-9 document. The whole way Immigration Services put I-9s together is you go by the expiration date on the documents you were given unless you get some information to the contrary. And so you probably want to be able to create that same environment with the H-4 EAD.
Okay, and a very last question. We're a minute away from our close time. If a H-1B worker leaves an employer and the employer withdraws the I-140, does that wipe away the basis of the I-14 EAD, or the H-4 EAD?
Right. And as we said earlier, and I think Upwardly Global said they'd make these slides available to you so you can read it and go through it again, but it's possible. It's possible that the USCIS could go back and revoke an EAD if the I-140 has been withdrawn or is no longer valid or revoked in some case. The fact that the Immigration Service has said that does lead one to believe that the EAD is valid until it's revoked. The fact that they would put a process together to revoke an EAD, I think you could come to a legal conclusion that that EAD is valid until revoked.
Okay. Well, Cynthia, thank you very much for your expert opinion and guidance, and thanks everybody for joining the webinar. If we have recorded the webinar, so if there are colleagues that would like to listen to this, please let us know, and we also have a copy of the slides available for you if you want to email us regarding that. Best to everyone, and thank you so much for your participation.